Thank you, Madam Speaker. To the bill.
To the bill.
Colleagues, I urge a no vote because this bill is really a line between philosophies of the role of our government. And I want to begin my comments with complimenting my friend, our state representative of inner Southeast and Northeast Portland, for his passion to see Oregonians receive opportunity. I share that passion. He did, however, say that in Oregon, every time you apply for a job, and I think his quote was every single time, you face this box. And I just want to be able to correct for this record that that's just not true. And in fact, Walmart doesn't have that. Bed Bath & Beyond doesn't have that. Home Depot doesn't have that. Koch Industries doesn't have that. Our private sector is making changes all the time. And in fact, a 2012 study said it was only 60-some% that had a ban the box, if you will, or had a box on an application. So the question is, are we going to allow the private sector to make choices again for what they believe is right for businesses that they own, not us? Or are we going to once again imagine a social justice utopia and compare it to where we are now and keep striking down law after law after law as we impose more government mandates and restrictions on private business, all for a good end? It's a good end. But here's why it is inherently self-contradictory. In Section 1 of the bill, it says that it would be an unlawful employment practice, which, for those who have practiced law in the state, means one thing to plaintiffs' attorneys: ka-ching. Because you have attorney fee provisions, you get compensatory damages, you can bring punitive damages against employers. Employers are sued all the time. So now we make an unlawful employment practice, number one, use job application forms that inquire into the conviction history of an applicant for employment. That's the box our good representative from inner Southeast and Northeast Portland just referenced. That's the box. That's not what this bill stops at. It goes on. Inquire into or consider the conviction history of an applicant for employment prior to conducting an interview with the applicant. Well, now we're not talking about an application. We're talking about whether an employer inquired into or considered the conviction history of an applicant prior to conducting an interview. So in other words, you don't have to have a box on your application. But if you inquire into or consider the history of someone prior to an interview, you are committing an unlawful employment practice. Now, the irony is, under the situation that our good representative just said, that could still be an unlawful employment practice. There doesn't have to be a box. And then third, inquire into or consider the conviction history of an applicant for employment prior to making a conditional offer of employment to the applicant when no interview is conducted. Here's what I want to throw out to you. If a plaintiff's attorney makes a case and says, look, you may not have had a box on an application, but you didn't give an interview to my client. So I need discovery. I need to be able to know, did you inquire or did you consider? That creates factual issues. Factual issues survive summary judgment. Cases that survive summary judgment cost $50,000, $60,000, $100,000. We've got employers all over the state struggling to pay the bills. Employers doing the right thing. And yet again, for the umpteenth time.
Representative Hack yields her time. Please continue.
And yet again, this floor is about to pass a bill that somehow treats every employer as if they're an evildoer. When the fact is, all the trends show the private sector is actually going the other way. They're actually heading the way to where they're considering qualified applicants regardless of criminal history. So then, why does Oregon have to make it a mandate? That will simply subject good employers to lawsuits again and again and again. Our good friends at Boley will get involved too. You can look down in Section 2. It amends the bill 659A.885. Boley, who this floor wants to give cease and desist authority to in orders. Colleagues, there are ways to get those who have served their time better jobs. And I certainly would be supportive of that. This goes beyond just simply banning the Biocs. This, in the end, will only drive people to take defensive practices against litigation. And those defensive practices will not serve qualified applicants with criminal history. I believe this well-intentioned but horribly misguided law will actually hurt the very people it wants to protect, all while hurting good employers all across the state. But there is one group who's simply delighted. That's called the Plaintiff's Trial Attorney Bar. They win again. I urge a no vote.